Good morning, everyone. Let me get started here.
The big day has finally come. The trial in the saga of Whose House Is It? If you have not yet seen the previous parts of this saga, it is well worth your time to check them out. We will include the links in the description below. In this video, we're going to get some preliminary matters out of the way to set up for the trial to follow. And it starts with a motion for contempt against Miss Blair.
Good morning, everyone. We're about to go on the record. We're continuing the matter, complicated matter of Rosemary Blair versus Joseph O'Donnell and Carla Bowers. It's had quite a procedural slog through the system, been adjourned several times, continued several times. I blocked out the entire day today for the matter. We have two new attorneys that will be appearing here, Robert Soltis for Rosemary Blair, and Jennifer Wu will be appearing for Mark Verpalat, one of the third-party defendants. This matter is entitled Rosemary Blair versus Joseph O'Donnell and Carla Bowers. The file number is 221862. There are three third-party defendants, Mark Verpalat, Patrick Blair, and Karen Stiver. Attorney Daniel Hatch is here on behalf of Joseph O'Donnell and Carla Bowers. Mr. Soltis, why don't you go ahead and put your appearance on the record?
Thank you, Your Honor. Robert A. Soltis on behalf of Rosemary Blair. Ms. Blair is right to my left.
Good morning, Ms. Blair.
Good morning.
Mr. Hatch, why don't you go ahead and place your appearance on there as well?
Good morning, Your Honor. Dan Hatch on behalf of defendant counter plaintiffs Joe O'Donnell and Carla Bowers,
Who are both present also. Theoretically, this matter was set for a hearing regarding damages in this matter. As I indicated, it's got quite a procedural history. We were here on May 26th and made a pretty extensive record, and Mr. Hatch presented an order to reflect my finding where I denied plaintiff's motion to set aside the default. Mr. Hauser filed an objection to that, so that order has not been signed. It just simply states, for the reasons stated on the record, the court being fully otherwise advised in the premises, it is hereby ordered that the motion to set aside the default against Rosemary Blair is denied, which was accurate. But there's a question about whether it's denied with prejudice or without. I'm not sure what difference it makes. But anyway, that order has not been entered, but I did deny the motion to set aside the default. The default entered. There was, I believe, a non-timely motion to set aside the default, which didn't comply with the court rule. It was just a one-page thing that said I moved to set aside the default, so I denied the motion to set aside the default because it didn't comply with the court rule. Shortly after that, Ms. Blair indicated she didn't want Mr. Hauser to represent her anymore, and he was released from his obligations. So we didn't do what we had hoped to do on May 26th. I had, again, blocked out that entire day, or maybe just the afternoon, but I blocked out a block of time. So we searched for another day, and today is a jury trial day, and the two cases that were set for jury trial, fortunately, both resolved. So I blocked out all day. So Ms. Blair, at that point, asked for an adjournment because she didn't have counsel. Mr. Hatch objected to that, but I felt in good conscience she needed to have representation. It was clear she didn't completely understand everything that was happening here, not because she's ignorant, but because she's not an attorney. And so I did continue the matter. She was scheduled for a deposition on June 12th. And Was that the date, Mr. Hatch?
I believe it was June 16th, Your Honor, which was a Friday.
All right, June 16th.
Correct, Your Honor.
And there were some last minute scrambles. She requested to not appear. I denied that request. There was another attorney in there somewhere from Crown Point or somewhere in Indiana, said she has to be there. She didn't appear. So a separate record was made. She wasn't present. Mr. Hatch requested contempt, jail, attorney fees, and a number of other things. And that matter is somewhat left open as well. So we've got the issue regarding the entry of the original order. We've got the issue regarding the contempt of Rosemary Blair. And theoretically, this matter is set for a hearing regarding damages. I raised the issue multiple times regarding the plaintiff's request for damages in excess of $25,000. All of the third-party cases, the claim, counterclaim, or third-party claim is in excess of $25,000. By statute and court rule, the district court has jurisdiction in matters up to $25,000, including landlord-tenant matters. And the court rule, it's in 4.2 something, 4.201, doesn't really give the court discretion. It says if either party moves to remove the case, the court shall remove it to the circuit court, not may, shall. This comes up several times a year. So that issue had never been joined. It was discussed. Mr. Hauser never made such a motion, and neither did Mr. Hatch, and the court didn't make one on their own. Frankly, I didn't want to dump this matter all on the circuit court. It's complicated, it's fact-specific, it's got a lot of previous court proceedings, and to remove the matter, I think would put great amount of delay and expense. So in hindsight, maybe I should have removed it right from the get-go and let the circuit court start with it, but we did not. Mr. Soltis, who appears before this court quite often in landlord-tenant matters, has filed an appearance on behalf of Ms. Blair, and he's challenging the jurisdiction of the court to determine the damage question, and that it's over $25,000. Normally, the district court does not have equitable jurisdiction, but in some landlord-tenant cases, there is some equitable jurisdiction. And in this case, by default, I have ordered specific performance that she comply with the terms of the original lease, option to buy, or land contract, or whatever we're going to call it. So they've asked for specific performance. We want to buy this house at the agreed upon price, and that's been ordered. We haven't nailed the terms down, but that's in the pleadings. It was subject to the default. It was not set aside. So where does that leave us? Let's start first with the entry of the order. Mr. Hatch, you submitted the order as I directed, and it states that the motion to set aside the default was denied for the reasons stated on the record, which I've restated here. Do you wish to speak to that any further?
I do, Your Honor. Thank you, Your Honor. Dan Hatch on behalf of Joe O'Donnell, Carla Bowers, and may it please the court. You're right. The May 26th order, I drafted it. I submitted it under the 7-day rule. A couple things. Number one, Mr. Hauser was terminated as Ms. Blair's counsel on May 26th in front of this court. He withdrew his counsel. He no longer represents Ms. Blair. The court denied the motion to set aside the defaults because it found, as we briefed, that there was no meritorious defense and no good cause to set aside the default. So I offered to submit an order. I submitted an order under the 7-day rule. It stated that the motion was denied for the reasons stated on the record. And I put with prejudice, as I do on most motions, because you can't just bring the same motion over, and there's a way that you can seek relief from the court. It's called a motion for reconsideration. You can't just file another motion because you hire a new attorney and now you want to try to bring it again. So that's why I put in the order it's denied with prejudice, which it was. Ms. Blair, Mr. Soltis could file a motion for reconsideration, which they have not done so far. So number one, the order is accurate. And number two, it's precarious that Mr. Hauser would be filing an objection when he doesn't represent Ms. Blair. He was relieved of his duties to represent Ms. Blair. He still is counsel of record for Karen Stiver and Patrick Blair. He has no standing to object to an order that has nothing to do with his clients, who are Karen Stiver and Mark Verplat. So for the reasons that the order is accurate, and the fact that Mr. Hauser doesn't have any standing, we would ask that the court enter the order as it was submitted. Thank you.
Mr. Soltis, do you have any comment regarding that?
Yes, Your Honor. A couple things. If the court is ordering that order that was presented be entered, the time for reconsideration hasn't even begun, never mind passed. So that's still open. I've gone and looked at the tapes that we were made of the hearings in the past. I don't believe the court said with prejudice or without prejudice. So what my request is, Judge, just strike out that last language and let the order accurately state what you did. You denied the motion.
And I didn't state it, so that is what I'm going to do. I'm just going to take that out. Counsel's right. You can't just refile the same motion over and over again, but there is a way to do it. So I've stricken the last two words with prejudice, and I've signed the order. Somehow it's got a 2/20. So the date of the order is today, 6/28/23, denying the motion to set aside the default. It has the same effect. That order remains, including the order for specific performance. All right, the next issue is regarding the contempt of the defendant, Rosemary Blair. Mr. Hatch was quite vocal in his objections. He was here. I don't think they ended up bringing all their everything they needed, but he was here prepared to do the deposition. She was told on the record she was to be here. There was an order denying her request to not come, and she did not come. So we're here for today's hearing. Mr. Hatch has not had an opportunity to depose Ms. Blair. She wanted to tell her side of the story. And she said, when do I get my turn? And I said, well, they'll get the turn at the deposition and at a later hearing. So this record was made without counsel being here, without the defendant being here, and I didn't make any finding. So at risk of having you say everything all over again, what's your position regarding the contempt of the plaintiff, Rosemary Blair?
Thank you, Your Honor. I won't rehash everything that we talked about on the 16th already, but the motion for direct contempt was entered by the court on June 16th. So as I stated, we've got various sanctions and relief that were requested in the motion. Some of those are moot at this point, but at this time, we are asking for two forms of relief for the direct contempt. So under MCL 600.1721, following the finding of civil contempt, the court may order any or all of the following sanctions: a fine of not more than $7,500, a coercive conditional jail sentence to compel the party in contempt to comply with the order. I understand the court has denied that. And if applicable, damages for loss or injury caused by the contempt conduct. So it's up to the court to decide whether they want to impose a fine. We would be asking under MCL 600.1721 for damages for loss or injury caused by the contempt conduct. Those damages are, as we state in our motion, $6,500 that we incurred. And that's not the total expense, but I think that is a reasonable expense for Ms. Blair failing to show up for her deposition twice. She failed to show up for her deposition on May 16th, and she failed to show up for her deposition in direct contempt of this court's order on June 16th. So I prepared for Ms. Blair's deposition twice. I drove to Mr. Hauser's office. Here is the deposition exhibit book with all the exhibits that I was going to go through with Ms. Blair. It was going to last all day, 7 hours. I spent a significant amount of time preparing for a deposition of a critical witness in this case. So it's not like something I was just going to do in 2 or 3 hours. I spent a lot of time preparing twice for a deposition. So at my rate of $395 an hour, which is reasonable under the per group factors and under the State Bar of Michigan State Law and Economic Digest, it's 16 hours, which would be very reasonable for my travel time from Grand Rapids to Kalamazoo to Mr. Hauser's office, which Ms. Blair didn't show up to, and from Grand Rapids to the courts, which Ms. Blair didn't show up to, in addition to the preparation for the deposition twice. So those are the money sanctions we're asking for. Also, as a sanction for her failure to comply with discovery, MCR 2.313, which is failure to permit discovery sanctions, under section MCR 2.313 B2 subsection B. If a party or an officer, director, or managing agent of a party, or a person designated under MCR 2.306 to testify on behalf of a party fails to obey an order to provide or permit discovery, including an order entered by the court under subrule A, the court in which the action is pending may order such sanctions that are just, including but not limited to the following. So subsection 2 has been met. Ms. Blair failed to appear for her deposition and permit discovery twice. Subsection B states, an order refusing to allow the disobedient party to support or oppose designated claims or defenses, or prohibiting the party from introducing designated matters into evidence. So in addition to the monetary sanctions, we are asking for the sanction to prohibit Ms. Blair from supporting or opposing our claims today for damages. And that's probably the next issue we're going to get into, which is what are the claims and what damages you're going to be presenting. But that is the sanction we're asking. There's no trial by ambush. I have the opportunity to depose Ms. Blair before the trial. If she wanted to tell her story, she should have come to the deposition twice. It's not fair for her to duck out in a deposition and then try to hoodwink us at trial by going up and testifying when I haven't had an opportunity to depose her. If that was the rule, no party would ever show up for a deposition. They would just try by ambush every single time. So there's reasons for depositions. Ms. Blair chose not to show up for a deposition, and there's a court rule specifically stating that if the disobedient party fails to permit discovery, i.e. a deposition, that the court can prevent her from supporting or opposing the designated claims. That's directly on point and what we're asking here for today. So $6,500 of our expenses incurred for the direct contempt, and then also prevent Ms. Blair from testifying, opposing our claims, or admitting any evidence in this hearing or any subsequent hearings in this matter. Thank you, Your Honor.
Mr. Stoltz?
Yes, Your Honor. Ms. Blair informed the court that she couldn't be here because of a doctor's appointment. And that information, according to the Register of Actions, was transmitted to Mr. Hatch before the death. So, and then my understanding is he came down here and he was down here anyway. He said to the court, yeah, I'm down here anyway. So, let me take care of that. Well, Your Honor, first of all, if he drove to Hauser's office, I don't know that. I've not seen any bill of cost here or anything like that. So I don't have that information, so I can't respond to how much time and whether or not that's reasonable. If I had it, I could, but I don't. Second of all, Your Honor, when he says he has to prep twice, I don't think I would do that, and I don't think that's reasonable.
I can identify. I've had this file out 15 times, and I get all ready to go, and one day we got tornadoed. It was nobody's fault. And I had everything, spent 2 days going over everything, was ready to go, and the tornado never came, but they shut the courthouse down. So we had to move it. Then I had to do it all over again. Then we were here on the 20th, in the date in May, and I prepared everything. And Mr. Hauser was removed, and so we didn't do anything. So I had to prepare all over again. So I can identify with having to get ready over and over again. My memory isn't what it was when I was 25, and so I have to reacquaint myself every time I have to dive back into this big, thick file.
Well, I understand that completely, Your Honor. However, Mr. Hatch claims that he's got a big old binder here, which means he prepared. And for him to go through that all over again, I think would either take a very little time, if he's even going to go there. I normally write down my questions before a deposition. And oh, by the way, if I have to take the deposition later on, I look at my questions, they're already there. So it's not a chance where he has to go through the whole amount of evidence that you had to go through, but just whatever he wanted to ask of Ms. Blair. And Your Honor, there was no trial, and right now there is no trial. So I think the sanctions, yeah, there should be some money sanctions against Ms. Blair. $6,500, I can't tell you whether that's good or bad or indifferent, but I do think it's maybe a little, maybe high. I think Ms. Blair should be able to question the damages and present evidence that, you know, the evidence is not correct. One of the issues in this case that I know the court has mentioned before is how much money was given to Ms. Blair for representing the down payment, if you would, on the lease option. It's not a land contract, the lease option. And, you know, that is probably going to end up being determined by the circuit court. I've talked to Mr. Hatch, and I think we both are in agreement. He can disagree with me if he wants, that because of the fact that the court doesn't have the jurisdiction over $25,000, if the damages here go over $25,000, that's got to go up to circuit too. And I know it's not the ideal resolution, because I know the court doesn't want to send this up to the circuit court, because yeah, it'll take a bit. But on the other hand, if it goes over $25,000 and Ms. Blair is required to appeal, that's going to take even longer. And, you know, I don't think I think the only solution is to send this to circuit court. As for the deposition.
Well, why don't you go ahead? You sort of segued into your motion regarding jurisdiction, and why don't you address that further?
Your Honor, if I could just, before we segue into the jurisdictional issue, if I could just make a couple comments about the cost.
Yes. Stop. I'm ordering $6,500 in costs.
Okay.
She explicitly did not have my permission to not appear. I told her to be here. I did an order that said she didn't have the right to be here. I think it was a pretext that she was trying not to come. So you prevail. I'm not ordering 7 days jail or a $7,500 fine or the other things you asked for. However, I am ordering your costs. So you may do an order that Rosemary Blair, as a sanction for contempt, shall pay $6,500.
And Your Honor, we did put in the motion as well, because I've ran into this issue before, that, you know, when is that due and payable? So we have asked that she tender payment to undersigned counsel to my firm ILS account within 14 days of the court's order, just so that there's a cabin dates on when it is due.
Your Honor, because of the amount, I would ask that it be 30 days.
That's fine.
And just very, very quickly, Your Honor, I don't want to get into it. I understand the $6,500, but to Mr. Solis's comment about prepping twice for a deposition. When I showed up on May 26th,
You already won.
I know,
so
but
I may just make you feel better. But
I take offense to the fact that if someone thinks that I'm churning the file, I don't work like that. When I showed up to Mr. Hauser's for the first deposition, we had a very good conversation about a lot of things that he didn't know about the case. And he turns over to me a massive file that he failed to produce in response to our discovery request. So the additional amount of damages, it was not just me going through my questions again. It was I added a significant amount of exhibits because there was a lot of documents that had not been produced before that day. I just wanted to put that on the record.
all right. Well, you can do the order. The defendant has been found in direct contempt on the 26th of May. As a sanction, I'm ordering she pay $6,500 in costs for her failure to appear. I'm not ordering any jail sanction. We have yet to address the issue of whether she can present any evidence, but as indicated, that may not end up being here. You can do the order. 30 days from today would be July 28th. Again, I stated my position on this. Maybe in hindsight, I should have just sent it upstairs right from the start. But I was hopeful I could get this case over the finish line. Mr. Soltis has come into the case on very late notice, and he went right to the pink elephant in the room regarding the jurisdiction of this court to hear the damage claim. Mr. Soltis?
Yes, Your Honor. As I presented in a hearing brief that unfortunately I was only able to file yesterday, is that whenever there, the court rule and the statute and the case law all says that the court cannot has no jurisdiction to enter orders over and above the $25,000 limit. And every one of the claims from the counter complaint that are for damages are asking for $25,000 or more in excess. And as my brief pointed out, Your Honor, you look at right at the beginning. You don't go way down the line and wait and see if they can prove it. You have to look at the beginning. And if the claims are on their face in excess of $25,000, they need to go up. And Your Honor, I also put in the fact that when there's two exceptions to the rule that attorney's fees are generally not included as damages, but that's beyond the point. But I'll just say it anyway. The two exceptions, as I noticed in Michigan, is if there is a statutory basis for the attorney fees that will allow for attorney's fees. And Mr. Hatch has pled MCL 600.2191A, which certainly provides for attorney's fees if it becomes that way. And based upon what we hear today, that's going to be well over $25,000. So, Your Honor, I think the only issue that I think the court can address today jurisdictionally is the
Specific performance?
right. And the court has already done that. So when we get to specific performance, well, I think it's premature as to what happens because, there's the contract has to be followed. There has to be certain requirements, notice 90 days and all that sort of thing in a closing. We don't know if that'll happen yet. And if it doesn't, then the specific performance, I think, just dies because if Mr. O'Donnell and Ms. Bowers don't specifically perform as the court has ordered, well, then they don't get the property.
Well, there's another wrinkle in this. In August of 2021, when the inspection took place and that Mr. O'Donnell and Ms. Bowers were removed from the house, that the closing date, I think, was November 30th, maybe November 1st. Anyway, it was in November. Interest rates were probably 3.8%. And the testimony I recall from earlier representations were that they had been working with a bank to secure the financing to close by the date in the lease option to purchase. There was also testimony that they'd been making monthly payments. That was disputed, just like the large payment that they contend, but they also contend they were giving her, I think, $2,000 a month. Anyway, to close the deal in August of 2021 would cost them X amount of financing costs. To close the deal in August of 2023 is 2022. 2023, it's going to be more expensive for them to borrow the same amount of money. So that is part of the damage question rather than the specific performance. Purchase price for the house was $450,000. There's also a dispute as to how much was paid in advance.
Right.
So let's assume that their representation is correct, that they've paid her approximately $120,000. Now, there have been escrow payments being made each month here, which the court is also holding. So let's assume there's $130,000 that have been paid by the defendants. That leaves $320,000 to specifically perform the contract. The problem is that earlier money is in dispute. So your statement's got some validity. How do they specifically perform the contract? I guess they could come in with $450,000 and say, I want the title of this house, and then fight about the rest of it. But it isn't as simple as it was at the time they were removed from the house. So you are specifically requesting this court to remove the matter to the circuit court.
Correct. And Your Honor, let me kind of elaborate on my thoughts on this. First of all, if there was a provision in the agreement that says they're going to buy the house at $450,000 at 6%, and whatever percent, and the interest rates are above that now, or when they actually do try and buy the house, I guess, they actually exercise that option, then we will know that as a measure of damages. But the contract doesn't provide for that. It provides for...
Well, you give me the money, we don't care how you get it.
Right, and there's a chance that, Mr. O'Donnell and Ms. Bowers can pay cash, and there goes the whole interest aspect of it. They pay cash, we don't know where it came from, and we don't care. But if they pay cash, then they're not financing, and the interest rates are, I think, irrelevant. Plus, between now and then, I think the interest rates may change. In fact, I'm confident they'll change. Come on, the way the Fed's been doing it, they've been changing the rates about every other month.
All right, thank you. All right, we'll hear from Mr. Hatch and see what he's got to say.
Thank you, Your Honor. I think there's a really easy solution to this, and I agree with about 70% of what opposing counsel said here. So, which is good.
Right.
So it's a good start.
It's better than zero,
It is.
I guess.
It is. We would stipulate to bifurcate this case as to certain claims that exceed the jurisdictional threshold of the district court. The claims in this case are count 1, breach of contract, count 2, specific performance, count 3, violation of the anti-lockout statute, count 4, tortious interference, count 5, summary proceeding, count 6, quiet title, count 7, civil conspiracy, count 8, common law conversion, count 9, statutory conversion, count 10, trespass, and count 11, claim and delivery. So I believe the court was...
Where was specific performance in there under breach of contract?
That is count 2. It's right after breach of contract.
All right.
MCR 4.002, which I think the court was referencing, states, if a defendant asserts a counterclaim or cross-claim seeking relief on an amount or nature beyond the jurisdiction or power of the district court in which the action is pending, the court shall either order the action transferred to the circuit court to which the appeal action would ordinarily lie, or inform the defendant the transfer will not be ordered without motion and notice to the other parties. So I think that's where you start out. But you have to specifically look to MCR 4.201. And that specifically has to do with removal of certain claims from the district court. MCR 2.401 subsection G2, claims and counterclaims. Removal.
Give me a second. All right. What section are we referring to?
Subsection G2, titled removal. G2, subsection A and B.
Okay.
Subsection A states under removal, a summary proceeding action need not be removed from the court in which it is filed because an equitable defense or counterclaim is interposed. Subsection B, if a money claim or counterclaim exceeding the court's jurisdiction is introduced, the court, on motion of either party or on its own initiative, shall order in accordance with the procedures in MCR 4.002, which is the original one we just went over, removal of that portion of the action to the circuit court if the money claim or counterclaim is sufficiently shown to exceed the court's jurisdictional limit. So Ms. Blair has asked that the court just kick it all up to the circuit court. It's not how it works. So we would agree to bifurcate this case, the claims in this case, with respect to count 1, breach of contracts, because the damages do exceed $25,000. Count 3, violation of the anti-lockout statute, over $25,000. Count 4, tortious interference. Count 7, civil conspiracy. Count 8, conversion. Count 9, statutory conversion. Count 10, trespass. Count 11, claim and delivery. We want to do that for a couple reasons. Number one, we want to make sure that this case is appeal proof. And also, we want to make sure that if we're in district court for our money damages claim, we're capped at $25,000. We don't want that.
Well, or if I granted more, certainly it'd be subject to appeal, and nobody wants to do this twice.
Right. So those are the money damages claims. So we will stipulate under MCR 4.201, and I've had conversations with both opposing counsel before today, that we'll stipulate to count 1, count 3, count 4, and count 7 through 11. The court does not have to and should not kick up the claim for specific performance, summary proceeding, and quiet title. Those under MCR 600.8302, equitable jurisdiction of the district court, this court has jurisdiction under those claims. Specific performance is an equitable claim. It's attached to a breach of contract claim, but we're asking for equitable relief in the form that hopefully we'll be presenting here today. Summary proceedings, again, the district court has exclusive jurisdiction over, and also quiet title. So MCL 600.8302 subsection 3 states, in an action under Chapter 57, which is the Summary Proceeding Act, the district court may hear and determine an equitable claim relating to or arising under Chapter 31, 33, or 38, or involving a right, interest, obligation, or title in the lands. That's what our specific performance claim relates to. That's what our summary proceeding claim relates to. And that's what our quiet title claim relates to. So the solution, to this puzzle is simple. We will stipulate to bifurcate the case with respect to the claims that I identified, and the court should hear, because you've already entered a default, not a default judgment with respect to count 2, 5, and 6. So we're here today, and it would be a logistical nightmare to try to transfer those claims. This court's heard this case for 6 months. We're at the finish line, so we asked to proceed with count 2, count 5, and count 6, and the time is today to proceed with those claims. So you don't need to kick the entire case up to the circuit court. The money damages can go up there. We'll have a hearing on money damages for those claims, and then the summary proceeding, specific performance, and quiet title will be handled by this court. Thank you, Your Honor.
All right. Before you respond to that, how do we accomplish specific performance? As Mr. Soltis says, if they come in with $450,000, we don't care where it came from. So I would order that, and the problem is for your client, let's just assume, as she argues, she's received zero. That's not accurate because there's some money in escrow, probably $6,000 to $8,000. They paid 3 or 4 months worth of payment in escrow. But absent that, they've got to come up with a whole $450,000. Then I order that they quiet title and the summary disposition for removal is denied. And they pay $450,000. They get the house and the deed. Then your next 2 years fighting over damages in circuit court. Is your client prepared to do that?
The way that I see that's the most efficient process, Your Honor, is that we have a hearing. So the court has entered a default, not a default judgment on specific performance. Default establishes liability. A default judgment establishes damages or the remedy. So while the court has already entered default for specific performance, we need to offer proofs here today to address exactly what the court said. Ms. Blair claims she received $30,000. We will present evidence today that's incorrect. That goes into the amount that they paid under the land contract, which then goes into how do we determine the equitable remedy of specific performance. So we do need to put proofs on here today to enter a default judgment. Again, I want to make this appeal proof. Just the default doesn't do anything for us today. The court has to hear our proofs as far as formulating the equitable relief under specific performance. So, and this will be part of our trial here today, is that equitable relief is beautiful for specific performance. The court has discretion to create a lot of different remedies. So we will be asking the court to compel compliance with the closing of the transaction, the original 90 days, as set forth in the land contract, less the payments that have already been made to Ms. Blair, which we'll enter proofs with here today, and that she, it's in our complaint, but that she tender the sale and the instruments for delivery of the property over to my clients. And then that amount will be offset through set off and recoupment, which the court has the equitable remedy to do, from the amount of damages that are determined in the circuit court.
See, I'm not going to do that. At least we won't be able to accomplish that within 90 days.
Well,
I'm willing to hear testimony regarding your contention that certain amounts were paid. Your set off in attorney fees is probably going to be in excess of $100,000, but I'm not going to fry that fish here. That's going to be a circuit court matter. You do have a leg to stand on regarding the first portion. As a practical matter, I could just remove the whole thing to circuit court. I didn't want to do that. If the matter is removed to circuit court, you might assume this is going to take 2 years. All the transcripts of all the proceedings are going to have to be prepared. Judge Stutzman's going to have to familiarize himself with all these complicated claims and counterclaims and previous orders entered by the court. They've got to schedule it for hearing. There may be further depositions. It's going to take a long time and cost a lot of money. If I can accomplish the specific performance and give the buyers a certain dollar amount and date and compel Ms. Blair to tender the deed, that portion is done. They would own the house. Then you can spend 2 years fighting about the money. But I'm not going to go down the rabbit hole of all of the other stuff to offset the amount. If you want it removed to circuit court by stipulation, that will be a money question. So, Mr. Soltis, regarding Rosemary Blair's specific performance claims, he proposes to present evidence as to how much was actually tendered so I can give a figure for the defendants to comply with the purchase price. What's your response?
My response, Your Honor, is that specific performance means exactly that. Specific performance with the lease agreement. And if you look at the lease agreement, there are provisions that even after 90 days, we won't know exactly what the amount is, because it says, in the event there is an unforeseen delay for any reason, the purchasers shall pay $1,000 monthly until financing is secured. Will they pay it? And, in my opinion, this is still a question of whether or not they will actually exercise that option. And if they don't exercise that option, they don't get the house.
Correct. But I'm going to tell them you've got to exercise the option by a certain date for this amount of money.
And they need to also follow the other requirements of this contract. Do they not?
Yes.
Okay.
Which are what?
I just told you. It's $1,000 a monthly if it isn't. If they cause damage.
Well, right now they're paying $2,000 a month into escrow by court order. And to my knowledge, they haven't missed any payment. So, all right. This is going to take us all day, but that's why we blocked out the day. I'm going to allow you to present evidence regarding the amount that you contend your clients have paid, either in direct lump sum or in monthly payments. And Ms. Blair is precluded from testifying in opposition to that because she didn't show up for a deposition twice. So I'm going to take your evidence essentially unchallenged. He can certainly cross-examine and argue about it, but you're right. If you could fail to appear for a deposition, then show up at the trial and give your testimony. What's the point of compelling a deposition? You just duck it by not appearing. So you can't have it both ways. So we're going to take a recess. I will accept defendant's offer to remove all of the money claims to circuit court. Mr. Hatch, I'd ask you to do an order to that effect.
Certainly are.
And we're going to address the 3 non-money aspects of the complaint: summary proceedings, specific performance, and breach. Oh, what's the third one?
Quiet title.
Quiet title, yeah, obviously it goes with that. So we'll take a recess, we'll come back, and we will start with that.
Your Honor, then moving on to the other 2 other counts. For example, count, I think it's, I can't even read my own writing. Count 5 is summary proceedings. We've already ordered that Ms. Bowers and Mr. O'Donnell are in the house and denied the summary proceedings brought by Ms. Blair. So I think that's already done.
I think so too.
And, and I'd be willing to stipulate that they can stay in the house until there is either a order of the court or they fail to go through with the option. But if they don't go through the option, we probably have to be here anyway. So that would take care of that, I think.
All right.
And the quiet title.
Well, quiet title goes with specific performance. If you're going to perform the contract, you've got to provide the title or the deed to the property.
Right, but I don't think this court can order the title quieted at this point in Mr. O'Donnell and Ms. Blair, or Bowers, because we don't know where it's going to go with regard to the option itself. Will they pay it? Will they not pay it? I don't know. When that happens, we'll be.
I guess, or when the terms of the payment are completed, the defendant would be obligated to provide a deed to the property.
I
So,
think that's within your order of specific performance.
yes. All right. So specifically, we're going to deal with specific performance. And we're going to try to figure out how much has been paid.
Thank you.
So, as I said, we blocked out the whole day. I went to bed early, got up early. Laura's really looking forward to this. Mrs. Blair, can you hear everything with the system?
Yes, I
All right,
can.
very good. I'm glad that's working for you. All
I
right.
never did before.
Well, I'm glad it's new and it's just for cases like this. So I'm glad you can hear everything. All right, let's take a recess. 9:45. We'll resume and jump off a cliff.
Thank you, Your Honor.